Hi, this is Chapter 3, Lecture Video. The Adjudication Process, Chapter 3, Lecture Video. Let's start off with Slide 5. You should have your PowerPoint open and your textbook beside you. The criminal complaint. Starting a criminal complaint, there are three options. The police investigate and make an arrest, a private party citizen's arrest, or an indictment by a grand jury. The standard for arrest is to show probable cause. Standard for conviction is to show guilt beyond a reasonable doubt. We talked about that in the last chapter. Probable cause is 51%. Beyond a reasonable doubt is close to 100%. In the criminal complaint, the initial document states the criminal charges. Let's look at page 56 of your textbook. Under the criminal complaint, the prosecutor decides which cases will be filed and what crimes will be charged. Police reports are frequently given to the prosecutor, and the officers are interviewed. In some locales, investigators assigned to the prosecutor's office may also be assigned to the case. Here in San Diego County, the district attorney's office has investigators that are assigned to various cases. Let's look at the following are some of the things that the prosecutor will consider for the case. 1, how strong is the case against the suspect? 2, did the police conduct their investigation thoroughly? Sometimes the district attorney investigators will do follow-up investigation work. 3, based on the facts in the police report, what crime was committed? 4, were the suspect's constitutional rights violated? And 5, how many witnesses are there and are they credible? And on page 57, criminal complaint defined. The criminal complaint is a document filed with the court to initiate criminal charges. It must contain information establishing what crimes are charged, the geographical jurisdiction of the court, the statute of limitations has not run out, and the name and address of the court and prosecutor are also included. Slide 7, arraignment. So the name of the arraignment could be called the arraignment, it could be called the first appearance, or it could be called the preliminary hearing. And the purpose is to inform a defendant of the charges against them, to appoint a defense attorney if they can't afford one, to set bail, to enter a plea, and to set the next appearance. Here in San Diego, when someone's arrested, they go before arraignment. They have arraignment within 48 hours of that arrest. That is where they enter the plea of guilty or not guilty, assigned an attorney if they need one, and then they set their next court appearance. Page 58, arraignment. This says exactly what we just said. Now let's look at that bottom of the bottom paragraph on page 58. The defendant will be asked to enter a plea of guilty and not guilty. Those are the most common, but they could also plead no contest. And the criminal court will treat the case the same as if they were pleading guilty if they claim no contest. But in civil courts, it can be treated differently, no contest. Slide 8, arraignment. We pretty much just said that. Probable cause hearing can be combined with the arraignment, and it must be within 48 hours of arrest. And that's usually the cases here in San Diego County are within 48 hours. Establishes there is enough possible evidence to go to trial on the charges. Okay. Slide 9, preliminary hearing is required in most states if an arrest was not based on a grand jury indictment. We'll talk about grand juries later in the semester or in the textbook, so it'll be clearly defined for you. It determines if a crime occurred. It determines if the defendant in custody should stand trial, and the rules for admitting evidence are very relaxed. If there is sufficient evidence, the defendant is bound over for trial. The prosecution files an information or details of charges. Let's look at page 59 and 60. 59, preliminary hearing. Most felony cases that have not been presented to a grand jury must have a preliminary hearing unless the defense waives it. Statutes rarely require preliminary hearings for misdemeanors. The preliminary hearing is a mini trial without a jury, and the primary purpose of the preliminary hearing is to have a judge hear the case and decide if there's enough evidence, 1, to prove a crime was committed by the defendant, and 2, require the defendant to face trial on the charge. Some states permit hearsay to be used at the preliminary hearing that would be not admissible at trial. California allows police officers to testify to hearsay at the preliminary hearing, even though the statement is not covered by an exception to the hearsay rule. We'll talk about hearsay rules later. This makes it possible to reduce the number of times the victim must appear in court and to introduce lab reports without calling the technician who conducted the test. I have a comment for that in a moment. And then let's look at the top of page 60. The defense has the right to ask the witness questions for the purpose of showing that they have not been truthful or they are mistaken. And by listening to all the witnesses, the defense can decide how strong the prosecutor case is. So, in my 9 years of working in law enforcement and as a forensic evidence technician, I testified more at preliminary hearings than anything else. I've testified in juvenile court, I've testified at parole hearings, I've testified at trials, various trials, but preliminary hearings, the most of all. And although we'll talk more about, I think it's chapter 7 and 8, about how someone could give testimony for a crime lab report. That's preliminary hearings. Often you do a lot of testimony on the lab reports, but I've never had anybody testify for me. I've always gone to court myself. All right, let's look at slide 10, grand jury. The grand jury hears evidence. Oh, we're talking about it right now. I thought it was in another chapter for some reason. They hear evidence to determine if a crime occurred and who committed it. It is required in some states under the Fifth Amendment. It's composed of citizens and theoretically independent from the prosecution or the police. They can call witnesses and they can hear evidence in secret. There is no defense counsel present. And they decide if a crime was committed. If so, they'll hand down an indictment. Let's look at the bottom of page 60. Grand jury. They review evidence. They take testimony. They decide if a suspect should be charged with a crime, but they cannot convict. Let's look at page 61. They are composed of citizens, not prosecutors. Each state is free to establish its own rules on the size of the grand jury and how they're selected, but there can't be racial or gender discrimination. The size of the jury, let's skip around that. They're independent from the police. And the prosecutor can present the case to a grand jury before or after the suspect is arrested. The grand jury can call witnesses, ask questions under oath. It's in secret. The suspect does not have to be informed at all that there is an investigation underway, and they don't have the right to be there. The suspect does not have the right to be at the grand jury proceedings. There's no right to have an attorney present in the grand jury room when a suspect testifies, nor is there a right to have the defense attorney present. The defense does not have a constitutional right to call witnesses or to cross-examine them. And all the way at the bottom of the page, it's a very interesting process. The bottom of page 61, at the conclusion, they'll hand down an indictment, which means they believe the suspect should be charged. And it's called a true bill of indictment. If the suspect's not in custody at that point, an arrest warrant will be issued and bail will be set by the court. An arraignment will be held on the indictment. Very cool stuff. Slide 11, suppression hearing, held by a judge before trial. It's based on a motion by either side to exclude evidence from being used at trial. The normal rules of evidence apply at the hearing. We're going to talk a lot about rules of evidence throughout this chapter. Most evidence is suppressed because of a constitutional violation: involuntary confessions, illegal searches. Page 62. Kind of in the middle of the first main paragraph, by knowing what evidence is admissible, both sides can more efficiently plan their trial strategy. If enough evidence in a case is suppressed, however, the defense can successfully ask for the entire case to be dismissed. So it's very important to the defense, important to both cases. Next paragraph, hearings are normally held after the prelim for felonies, and the main reason is if the case is dismissed at the prelim, then you don't need a suppression hearing. And the testimony at the prelim may alert the defense for a need for a suppression hearing. So it's usually after the prelim, but it's before the trial. All the way at the bottom of page 62, the judge will either make a decision on the motion at the time of the hearing or make a matter under submission and rule at a later time. I'm not going to read to you, but look at page 63, the examples of issues heard at suppression hearings.